Vikash. Good evening.
Hi, good evening.
Good evening. I think we can begin with our session. Hi, and very good evening to you all. Today, we'll be having our session on insolvency law. This course is part of our ACL3 program. And also, it is one of our featured courses for this month. And today's session, we will be discussing the conflict of jurisdiction between NCLT and civil court. And we have with us Mr. Vikash Shah, who is a gold medalist, graduate from NLU Bhopal, a qualified advocate on record, Supreme Court of India, and has over 13 years of experience in advising, representing both Indian and foreign clients in a diverse range of areas. He primarily focuses on disputes resolution and arbitration in respect of complex civil and commercial disputes. Welcome, Vikash, to ABC Learning. And now, without any further delay, I'll just hand it over to you. Over to you, Vikash.
Thank you very much, Achal. It's very great. A very nice intro for sure. So while I understand it's an IBC related topic, but what I have done that I have not restricted the concept of this particular topic to just ABC, but I have also sort of extended it to the jurisdiction of NCLT under companies law per se, because there are a lot of disputes under companies law or in relation to corporate governance, which a lot number of time goes into a civil court. People end up filing in either in a civil court or in a lower court or in a high court. So long back in 1960s, 70s, a judgment of Dulabai came, which was a constitutional bench judgment, and Justice Hidayatullah. And why I want to give a reference, because I think in the best way to learn law in our country is to read case laws, because that is where you get the actual crux as to how a law is to be read and implemented both. So you or me or any lawyer may have a view in terms of after reading an act, but the moment they get and they read diverse judgments, that is when they get to understand the real intent and more so the real application of law. So what I'm trying to say that before even IBC came in 2015, 2016, and of course Companies Act was there. So there also, of course, initially we had CLB, now of course we have NCLT. But there also there was a dichotomy in relation to whether on account of Section 9 of CPC, whether the civil courts will have jurisdiction in relation to all matters, all civil matters, including matters arising out of or in relation to Companies Act, or at that point in time CLB it will go, and now of course NCLT. So Dulabai is one of the most celebrated judgments on this aspect, and it continues to hold the field even today. Of course, now under the IBC regime and under the new amended 2013 Companies Act, we have specific provisions like Section 430, 408 of the Companies Act, which makes it very clear that all disputes or all suits or all proceedings, and they have given there is a exhaustive list which in relation to the affairs of a company there will be an exclusive jurisdiction of NCLT. Despite that, we have judgments wherein in certain aspects the court have entertained the jurisdiction of a civil court even after the NCLT coming into force. But of course, under IBC, we have a specific Section 60, subsection 5, which and in that subsection C, which gives a very wide and sort of a residuary power to IBC, and it is very clear that any and every action in relation to the resolution process and in relation to the CIRP, there will be exclusive jurisdiction of the NCLT and not of any other court. There again, we have in my this topic, I have included three most important judgments in this aspect of Gujarat Urja Vikas Nigam Limited, all Supreme Court, Tata Consultancy Services versus SK Wheels, and Embassy Property Developments, wherein in Gujarat Urja Supreme Court, which I will delve in detail in the latter part of this conversation. And one more thing, if anybody has any question, they can ask at any point in time. And embassy. So these three cases mostly. What I've divided that I have what I've done that I've divided my present topic into five subheads. First is I will deal with relevant statutory provisions under CPC and Companies Act 2013. Second is jurisdiction of NCLT to handle company matters and of course matters arising out of IBC. Then residuary jurisdiction, as I was just talking under Section 65 of the IBC of under IBC. Then the BLRC report and the Indian jurisprudence, which includes a lot of case laws. So why the first point is that why this dichotomy? Why NC one needs to first understand that why NCLT was sort of constituted or made. It's a tribunal. It's a statutory authority constituted under the Companies Act. It was constituted way back in 2000 by 2002 amendment. In 2005 there were case files as to the constitutional validity, and ultimately, of course, it came into the being. So we have to understand that NCLT is an expert tribunal which has been specifically constituted to deal with company matters, all matters arising out of or in relation to the corporate or company, and therefore it's an expert body with expert knowledge on this aspect. And therefore, in a lot of judgments also we see that the Supreme Court or the relevant high courts have gone into the object and purpose of constitution of NCLT, and that is how they have said that, and that is the reason why you have Section 430 under the Companies Act, as well as sections in the IBC, which outs the jurisdiction of all other court apart from NCLT in dealing with matters arising out of under the Companies Act or IBC, as the case may be. Now, coming back to Section 9 of the CPC, which grants jurisdiction to the civil court to sort of take cognizance of all matters of civil, which are civil in nature. And in the case of Ramesh Govind Ram versus Saira Humayun Mirza, it was held that this jurisdiction under Section 9 is expensive, and the onus to prove the ouster of this jurisdiction is on the party that asserts it, meaning thereby that if there is a party who says that no, this is a matter arising out of Companies Act, like in terms of shareholders or operation mismanagement or whatever XYZ, appointment of managing director or a declaration or fraud and so on and so forth, they can, if they go and someone files a suit proceeding against them in a civil court, and if they are arguing that civil court will not have jurisdiction on account of Section 430 or Section 65 or whatever the relevant sections are, it is on to them to prove how the civil court does not have jurisdiction and how NCLT will have the jurisdiction. And a very recent judgment of Justice D.Y. Chandrachud in Saw Rajni versus Saw Smita 22 judgment, the Supreme Court in fact observed, and even in this judgment, the Supreme Court has relied upon the judgment of Dulabai, and it said that even in cases where the jurisdiction of the civil court is barred by a statute like Section 430 or relevant sections in other statutes as well, the test is to determine if the authority or tribunal constituted under the statute has the power to grant reliefs that the civil court would normally grant in the suit files before them, meaning thereby that if the party can show that the relief which I am seeking today before the civil court can only be granted by the civil court and not by the NCLT. And if I am able to substantiate and convince the judge before whom this matter would be lying, that this is the relief which NCLT or any other tribunal, in our present case, of course, NCLT can't provide, then the jurisdiction of a Section 9 court of a civil court will sustain. So therefore, the proper forum to adjudicate on an issue is the civil court. Section 9 of the CPC excludes suit of civil nature, which is being empowered by the special act on the tribunal. Now, of course, I don't want to bother you guys by taking you through these various sections and all, but briefly telling you that the NCLT and NCLT came into being by virtue of the 2002 amendment, and it was vested with powers for far-reaching in respect of management and administration of companies. And the constitutional validity of these very provisions which enabled the constitution of NCLT and NCLAT was upheld by the Supreme Court in India versus R. Gandhi. And as I was mentioning earlier, since this is a special body to adjudicate over the matters relating to company law, it automatically should out the jurisdiction of civil court, and that has been held in a catena of judgments till date. Section 408 of the Companies Act, it basically vests with the NCLT the exclusive right to exercise and discharge its powers and functions conferred to it under the Companies Act, including under the IBC. Section 430 of the Companies Act, which is in line with Section 63 of the IBC, it bars the jurisdiction of civil court regarding subject matter that come within the purview of adjudication by the NCLT and NCLAT. Now, so if you see Section 280 of the Companies Act, it gives the delineates the jurisdiction of the NCLT, and they use the word that notwithstanding anything contained in any other law for the time being in force, this NCLT, this tribunal shall have jurisdiction to entertain or dispose of, and they have a list. I don't want to bother you with the list, but I'll just say one point. It says any suit or proceeding by or against the company. Now, in my view, it is wide enough to include everything under its ambit wherever one of the parties is a company, and whether such suits or proceeding has been instituted or instituted, so both prior and subsequent, in relation to even in relation to the winding up, will go to the NCLT. Then similarly, your provisions from Section 253 to 269 of the 2013 Act, which dealt with revival of Sikh industry. Of course, this has been now replaced with the IBC. So before commencement of the IBC, also Section 304 to 323 dealt with the provisions of liquidation. Those also provided that it will be within the exclusive jurisdiction of NCLT to deal with the matter. Before NCLT came into being, usually in the High Court, it used to be the company side of the High Court which has the jurisdiction to try those matters. Now, of course, we know that before NCLT came into being, that is prior to 2013, it was the CLB, Company Law Board, and the BIFR, which used to deal with matters, in relation to the affairs of a company. And of course, with the establishment of NCLT, which is empowered, as I read under Section 280, to deal with matter in relation to conversion of company from public to private, in relation to variation of shareholders' rights, in relation to matters relating to refusal for registration of shares and rectification of shares, in relation to reduction of share capital, compromise of arrangement between the company and its creditor, operation mismanagement, and all of these are with the NCLT and NCLAT. Also, what I would like to say that what is the rationale behind the Supreme Court saying in various judgments that NCLT and NCLAT, the entire structure, will have the exclusive jurisdiction to deal with matters in relation to the company or under the IBC regime? Is, see, it's not like you have one tribunal and there's no one to deal with if there is any fiasco, or if there is any mistake, mistake done by one of the NCLT. You have an NCLT. If the NCLT, for reasons you think, has not decided the matter properly, you have NCLAT. If NCLAT you don't think, then you have Supreme Court. It's a three-tier system which is envisaged in order to take care of any differences or any adjudication or any problems in relation to the functioning of a company or the person attached thereto. So I will. So basically, NCLT was established under Section 408 and CLAT under 410. Important word to keep in mind that in CLAT you can only go, or you can only file an appeal on a question of law. However, the appeal which goes from NCLAT to Supreme Court is only on a question of substantial question of law. Now, of course, while this difference is there, but nowadays, as a practitioner of Supreme Court, and at a practical level, on a day-to-day level, we see that all kinds of appeals are filed. Nobody gives a certificate in relation to whether there is substantial question of law or not. If a person is of your party is aggrieved by the order of NCLAT, they just go and file an appeal before the Supreme Court. Now, I'll very briefly tell you that what has happened in certain landmark judgments. So, in Durga Shankar Mehta versus Raghuraj Singh, the court, which was dealing with an aspect of what is the definition of tribunal, they said that the expression tribunal as used in Article 136 does not mean the same thing as court, but includes within its ambit all adjudicating bodies, provided They are constituted by the state and are vested with judicial function as distinguished from administrative or executive functions. Similarly, in state of Gujarat versus Gujarat Revenue Tribunal Bar Association, the Supreme Court observed that a particular act set of rules will determine whether the function of a particular tribunal are akin to those of the courts, which provide for basic administration. Now, why I'm reading this why I'm telling you about this judgment? Because these judgments basically say what are the functions of a tribunal, and in what cases it can be said that the tribunal is such and the functionality of the tribunal is such that it has the powers to give an adjudication, and it has a similar power to give all the remedies or relief to a party which a civil court will give. And once it can be shown that they can give it, you then a party for any reason whatsoever can't go and say that no, since this is a civil proceeding, I will go to a civil court, and therefore I'm not supposed to go to NCLAT or and not NCLAT. I'm not supposed to go at the first instance to NCLT. So these judgments, and of course, when you have section 430. So when you read section 9 of CPC with section 430 of Companies Act, if someone can show that the company is in relation to a company, if someone show that the proceeding is in relation to the company or the functionality or whatever in relation to a company, then if I do a conjoint reading of section 9 and section 9 of CPC and section 430 of the Companies Act, clearly means that the exclusive jurisdiction rests with NCLT and not with any other civil court. Similarly, in the case of Abdul Ghafoor versus state of Uttarakhand, the Supreme Court, while taking recourse to the jurisdiction of civil court, observed that the right to bring a suit of civil nature of one's own choice at one's own peril, howsoever frivolous the claim may be, unless it is barred by a statute, meaning thereby that if the relief which I'm claiming for is not specifically barred by a statute, then irrespective of whether my claim is frivolous or not, at my own cost and consequences, I have the privilege or rather the prerogative to approach a civil court, and therefore the civil court can adjudicate upon all the suits of civil nature unless its jurisdiction is expressed. Important is this. So even in the case of I was saying Dulabai, and in Dulabai they had relied upon this judgment of Lord Thankerton in Secretary versus Mass State, wherein he said that there has to be expressly explicit exclusion of the jurisdiction of civil court, or a clearly implied. So sometimes, in a lot of judgments when you read, you will come across, they say expressly or impliedly. Now, impliedly doesn't mean that I have to make too much of an effort to show that the jurisdiction of a civil court has been outstayed. Even if it's implied, it has to be clearly implied. It can't be somewhere hidden and a party is just making out to show that the jurisdiction of a civil court is outstayed. So it has to be clearly implied and explicitly expressed. Only then a court can consider the ousting of jurisdiction of a civil court. And in that context, in the case of Abdul Ghafoor versus State of Uttarakhand, Supreme Court said that while doing so, the court have been unanimous in holding that the term impliedly should not be given liberal interpretation. Rather, strict approach should be adopted, and clear implication from the statute is mandatory for ousting the jurisdiction of civil court. Now, as I was mentioning this case, I think everyone who is interested in this particular aspect should read the judgment of, while it may not be relevant. It may not be directly in relation to IBC, but because of course the judgment came in 1969. But it is very important in order to understand the concept as to why a particular tribunal or a particular body can be given the exclusive jurisdiction to the exclusion of a civil court. So that is the Dulabai versus State of Madhya Pradesh. It's a constitution bench, of course, Justice Hidayatullah. He gave 7 principles on bar of jurisdiction of the civil courts, and this I will read for the benefit of everyone. Just 2 points I will read, and I will not bore you with all 7 points. It says that where the statute gives a finality to the orders of the special tribunals, the civil court's jurisdiction must be held to be excluded if there is adequate remedy to do what the civil court would normally do in a suit. Such provision, however, does not exclude those cases where the provisions of particular act have not been complied with, or statutory tribunal has not acted in conformity with fundamental principle of judicial procedure, meaning thereby that if NCLT can't decide upon the veracity of, if someone questions that the applicability of IBC or Companies Act, because it is a body which is constituted under the Companies Act, or yes, under the Companies Act. The power to decide upon those will only be with the High Court or the Supreme Court, as the case may be. Second is where there is an express bar of the jurisdiction of court, an examination of the scheme of the particular act to find the adequacy or sufficiency of the remedies provided may be relevant, but is not decisive to sustain the jurisdiction of civil court, meaning thereby that on a holistic reading of the act under which you are seeking a remedy and a special body or a tribunal is constituted, it can be shown that it is adequate to provide the same relief which the civil court would otherwise provide. In that case also, the jurisdiction of the civil court will be ousted. So therefore, what is mandatory? It is mandatory to see that if the statute creates a special right or a liability and provides for the determination of the right or liability, and further lays down that all questions about the said right and liability shall be determined by the tribunal so constituted, and whether remedies normally associated with actions in civil courts are prescribed by the said statute or not. So in that scenario, there is no confusion whatsoever that the special body in our for our present case, that the NCLT will have exclusive jurisdiction to decide the cases. Of course, as we know that when there is a challenge to the provisions of the concerned act itself being ultra vires, then the specific tribunal constituted therein can't decide. It can only be a question decided by the constitutional courts, where the provision is already declared unconstitutional. You can't rely upon. Where the particular statute does not contain any system for a refund of tax collected in excess of constitutional limits or illegally collected, a suit will lie before a civil court and not that tribunal. Where a civil suit shall not lie if the orders of the authorities are declared to be final, or when there is an express prohibition in the particular legislation. This is because questions of correctness of the assessment, apart from its constitutionality, are for the authorities to decide. So these are the 7 tests which he gave to decide that in what scenarios the jurisdiction of the civil court will be ousted. Now, for us, very recently, there is a judgment of Justice Pratibha Singh in SAS Hospitality versus Surya Construction, wherein she held that the jurisdiction of NCLT in company law matters will be exclusive to NCLT, and it will not be a civil court. Of course, she relied upon Section 430 I don't want to bore you with the facts of this matter. I'll just give you the ratio of this case, where the High Court said that since NCLT is empowered to oversee and supervise the workings of the company, and also appoint such persons as it may deem necessary to regulate the affairs of the company, the jurisdiction to go into these allegations rests with the tribunal under Section 242 of the Companies Act, and therefore the exclusive jurisdiction will lie with the NCLT. Further, the court went on to delve entirely on the various sections, including Section 242 of the Companies Act, and says that NCLT has a power to pass such order as it thinks fit, including provision for regulation of conduct of affairs of the company in future. These powers are extremely broad, and in fact, the High Court went on to say that they are more than what a civil court do. Now here, there may be some difference of opinions, but it is, and this judgment has not been challenged before the Supreme Court, so it has attained finally as far as these aspects are concerned. In fact, the judge went on to say that the powers of NCLT are broader and wider than what can be exercised by a civil court in exercise of civil jurisdiction under Section 9 of the CPC. The NCLT, is, as I was mentioning, is a specialized tribunal constituted for the purpose of speedier and effective regulation of the affairs in the company. And ultimately, it was held that in the facts of circumstances, the civil court has no jurisdiction, and it is the NCLT. Now, I will shift to the aspect of under the Insolvency and Bankruptcy Code (IBC), how various sections, including Section 60 and Section 60, basically 60 subsection 5, have created exclusive jurisdiction in relation to all matters arising out of or in relation to the resolution of a company or a CIRP will be dealt only and only by NCLT. So the first case, which is in this respect, is the case of Shashi Prakash Khemka versus NEPC Menon. In this case, the Supreme Court held described the powers of NCLT as regards the matters under Companies Act, and of course, is relied on Section 430 to say that in matters relation to the companies, the NCLT will have exclusive jurisdiction, and the jurisdiction of civil court is completely barred. Then I will just read Section 65 three provisions, and it will make it very clear. It says that it's a non-obstantive clause, and it says that NCLT will deal with any application or proceeding by or against the corporate debtor, corporate person, any claim by or against the corporate debtor, corporate person, including claims by or against any of its subsidiaries situated in India. And this is the most important clause as per me, subclause C. Any question of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceedings of the corporate debtor or corporate person under IFC. Now, this is what I call a residuary clause, where this can be interpreted very widely. But of course, what is the core or crux of it? That it has to be in relation to the insolvency resolution or liquidation proceedings of the corporate debtor. So if there is, even let's say their company is under liquidation or subsequently went into insolvency or liquidation, as the case may be, but the issue is not directly or central to the insolvency, then a party can't argue. And I will show you the judgment where Supreme Court say this, where in the case of Tata Consultancy, then the party can go to the appropriate court, civil court or whatever it may be, and then the other party can't invoke the jurisdiction of NCLT. Yeah, that's right. Now, as per Section 60, subsection 3, an insolvency or bankruptcy proceedings of a personal guarantor of a corporate debtor pending in any court or tribunal shall stand transfer. So even that, since it is in relation to the IBC, it will come before the appropriate court of appropriate NCLT. Section 238 of the IBC, it's again a notwithstanding clause, and it says that anything inconsistent therewith contained in any other law for timing in force or any instrument having effect by virtue of such law. So that this is this gives primacy to the IBC. All of us know the purpose and ambit of Section 14, which clearly says that once you get an order of Section 14, nobody can initiate or continue a proceeding against you, because there has to be a calm period in terms of Swiss ribbons and even the scheme of the act is such. Now, before I delve into the three judgments of the Supreme Court, I just wanted to mention, and you guys can go through this, whosoever is interested, is this BLRC report, Bankruptcy Law Reforms Report in November 2015. This is, they delineated the vision of jurisdiction of NCLT with regard to issues arising out of and in relation to insolvency, and how it says that, in all these matters, NCLT should have exclusive jurisdiction. And by virtue of Section 238(14), which I just read, and Section 60, subsection 5, of course, of the IBC, this BLRC report has been given effect to. So I was mentioning what my apologies. So Gujarat Urja Vikas Nigam Limited, it's a judgment of the Supreme Court, wherein, in very brief, I'll tell you that Gujarat Urja had entered into a PPA with Stonefield for developing of a photovoltaic-based power project in Gujarat. Soon after the commencement of the project, it was paused multiple times, temporarily on account of heavy rain and turbulence. Hit by this, Stonefield incurred heavy losses and was forced into insolvency. Thereafter, Gujarat Urja issued notices for termination of the contract on failure of Stonefield to remedy the occurrence default as a result of the admission of CIR. Now, this dispute was pertaining to an ipso facto provision, that is, for termination of contract on event of default, which included, now there in the contract itself, it included the admission to insolvency. The NCLT allowed this application for injunction on the issued notice, termination notices, which was allowed by the NCLAT as well. The matter went up to appeal in Supreme Court, where the primary issue of jurisdiction of the NCLAT, NCLT NCLAT, subsequent to contractual obligations and its regulation under IBC was discussed. And what was held by the Supreme Court was that, relying on the powers of Section 65 of IBC, the Supreme Court held that NCLT and NCLAT have jurisdiction to restrain the termination notices arising out of contract obligation. But what is important to see here, that such decision was arrived at relying on the centrality of the PPA agreement to the CIRP of the corporate debtor. The court clarified that such wide discretionary powers can only be granted in terms of matters which are intrinsically related to the CIRP, and no other unrelated ground shall qualify for such invocation. Now, if therein, if the party, if Stonfield was able to substantiate or convey to the court or convince the court that the termination is not central to the insolvency of the CD, corporate debtor, and therefore it doesn't come under the realm of section 60 subsection 5 because it's not in relation to insolvency, and then I think the result may have been different. The Supreme Court, of course, referred to section 238 of the IBC and concluded that PPA in question falls under the term instrument, and that is what I was reading under section 60 subsection 5, 238, and IBC would prevail over it in such a case. Further, it was held that the words of section 60 subsection 5 subsection 65C clothes NCLT with jurisdiction to decide any dispute in context of insolvency proceedings, and nothing inconsistent contained in any agreement could override that. It can adjudicate on disputes arising out of contractual matters solely if it is in relation to the resolution process of the CD. And therefore, while there has to be a balance between the insolvency rights and the contractual freedom of the parties, the Supreme Court opined that the powers of the tribunal must be derived from the text of the legislation, and words cannot be added for that purpose. Now, thereafter came a judgment of Tata Consultancy versus SK Wheels. And of course, Gujarat Urja was distinguished in this case. And for a very brief background, there were certain facilities agreement between Tata Consultancy Services, TCS, and SK Wheels for conducting examination and educational institutions. And there were multiple breaches of the facilities agreement by the CD before they went into CIRB. Now, CIRB was initiated by TCS against the CD, which was admitted. Subsequently, termination notices were issued by TCS on account of breaches. The CD initiated miscellaneous application under Section 65C of the IBC for quashing of these termination notices. NCLT, of course, said that these notices termination has to be stopped in order to let the CD remain a going concern, and they passed an order of granting interim stay to SK Wheels. Their appeal was filed, and CLAT upheld the order, and the matter went to Supreme Court. And therein, interestingly, Supreme Court held that NCLT does not have residuary jurisdiction to entertain the contractual dispute which has arisen divorce the insolvency of CD. Now, if it was not divorce the insolvency of CD, then possibly they would have the order of NCLT and CLAT would have been justified. And herein Supreme Court distinguished Gujarat Urja case, and they reiterated that the Gujarat case, NCLT was granted wide-ranging powers solely because the insolvency itself constituted an event of default, and there was no other default committed by the CD therein. However, in the present case, pursuant to the facilities agreement between Tata Consultancy Services and SK Wheels for conducting examination in educational institutions, termination notices were issued by TCS on account of multiple breaches of the facilities agreement by CD, and therefore they said that the order passed by the NCLT and CLAT was not right, and they should have also examined the interim relief before passing the order. Now, in both the judgments, the Supreme Court has also relied on the judgment of Embassy Property Developments versus State of Karnataka. In this, the corporate debtor had a mining lease which was granted by State of Karnataka, and upon being admitted to insolvency, the resolution professional sought an extension from the government for the lease, and the proposal for extension was rejected by the government on the ground of violations by the CD. They have not mentioned anything of insolvency. Of course, a miscellaneous application was filed before the NCLT under Section 65C of the IBC seeking quashing of the government order and allowing extension of lease, which application was allowed by NCLT. Now, in this case, before the government chose to file a writ petition before the High Court, and the matter was remanded back to NCLT for fresh consideration. And therein, the primary issue of contention was the jurisdiction of High Court, since it came to Supreme Court to interfere with the order of NCLT in a proceeding under the IBC, despite the availability of statutory alternative remedy of this appeal to NCLT. The Supreme Court held, it is very important, that the contractual agreement was between the state and the corporate debtor, which is a matter of public interest governed by relevant statute. The decision of government of Karnataka to refuse extension is in public domain. Consequently, only a court of appropriate authority would have adequate jurisdiction to decide the matter. NCLT, being a quasi-judicial body, which is a creation of statute, cannot be elevated to the status of a superior court vested with the power of judicial review over administrative action. NCLT is not even a civil court, which has jurisdiction by virtue of Section 9 of CPC. It is considered well settled that a quasi-judicial body cannot have jurisdiction over matters governed by public law. Therefore, the Supreme Court held that while Section 65C is very broad in its sweep, as it covers any question of law or facts arising out of or in relation to insolvency resolution, but when there is a decision taken by the government or a statutory authority in relation to a matter which is in the realm of public law, then by any stretch of imagination, it cannot be brought within the fold of phrase arising out of or in relation to the insolvency resolution. And therefore, Supreme Court said that the High Court was right in passing the order, and they cannot take the shield of Section 65C to stay the termination issued by the government. So therefore, in light of whatever I have just said, we can conclude that while there is an elaborate groundwork regarding the residuary jurisdiction of insolvency courts with respect to question of law or fact arising out of on relation to CV, corporate debtors, insolvency, resolution or liquidation, and IBC is there, because those three judgments, and there are various other judgments as well. And it, of course, recognizes the residuary power of NCLT to extend over disputes, essentially, which is pursuant to admission of insolvency proceedings against a CD, and or which are central or intrinsic to the insolvency resolution of a CD. For instance, where the outcome of the dispute could lead to the death of the CD. On the other hand, the NCLT is devoid of jurisdiction over matters which do not fulfill the above criteria, or matters which relate to public law or public policy, or such other matters which falls exclusively within the jurisdiction of special forum. So I think majorly this is what I wanted to cover. If you or anyone have any specific query, I'm happy to respond.
Sir, I have one query.
Yeah.
If an operational creditor has filed Section 9 and it got admitted, and subsequent to resolution plan he is not getting anything, can he then initiate civil suit?
No, how will you? If you're not getting anything, if there is a adjudication, okay.
In the resolution plan,
let us reframe it. Let us reframe it. There is an operational creditor who filed a Section 9.
Yeah.
So you have chosen a remedy for, while IBC, well, technically speaking and legally speaking, IBC is not a recovery proceeding, right? The act has been held by Supreme Court in Swiss ribbons and so on. So many judgments which say that IBC should not be used as a recovery proceeding. But of course,
still, sir, if there is a provision in the act for the operational creditor, then something should have been there.
Yeah, I agree with you. See, okay. Let us try to understand your question. You have, of course, you are an operational creditor, means you have supplied some goods or services on account of certain payments which were to be made, which has not been made to you, and therefore you want to recover that money. My understanding is right?
Yes, sir.
Now, in this case, there are two remedies. If there is no arbitration agreement mentioned in your contract or invoice or whatever it is, let's say there is no such arbitration clause, the remedy under normal circumstances would be to file a suit for recovery. Now, you chose not to file the suit for recovery because whatever reason, and because you want to put pressure. That is what we do on a regular basis. We tell the client to file an insolvency, put pressure on them, file a Section 9, right? Now, if you have filed a Section 9 and when you are saying that you are not getting anything, what do you mean by that? Is there any adjudication by the court?
No. By that I mean, since I am an operational creditor, I don't have any say in the voting of the COC.
That's right.
So what is happening is the promoter has got the MSME certificate. He is buying his own company, and the financial creditor are supporting that.
Correct.
And in that resolution plan, there is nothing for the operational creditor, as the valuation is also very low. Assets are also not there.
Correct. So as the valuation is low, there is no asset. On a very practical, apart from giving you the technical answer, on a very practical level, even if you go and file a recovery suit, what are you going to gain? But technically speaking, once you have
legally, just I want to know. I know that.
Legally, I'm saying that once you have chosen a remedy of filing a Section 9, in my limited understanding of can't claim myself an expert. I don't see that you can again for the same thing you can go and file a suit for recovery. Because as far as your claim is concerned, it has been adjudicated upon. There is just whatever resolution plan which you would have considered, and the company has now gone
We can
to
only challenge the resolution plan.
yeah, that's
That's
all.
what
You
we
can
can do
only
within
challenge
the
the
realms of the
within
code
the
only.
realms.
We can
Absolutely, because see, once you have accepted it, in terms of once you have initiated or accepted whatever, you have become part of
yeah.
this
Not only
process.
we initiated, we have participated also.
Yes, yes.
Later on,
So
some financial creditors have filed the claim.
correct. Of course, they have to. They have to file
Yes,
it,
yes, yes.
otherwise their claim will go. So once you have participated and once you have initiated and participated, you can't go. In my understanding, you can't go and file a civil suit for the same claim.
Got it, sir. Suppose I would have
Also,
filed
because
civil
if I
suit.
may add, also because
One month.
if I may add, since the registration process is approved and then now a new management comes. Once a new management comes,
That
as
new
per
management is that but same guy only, sir.
so
Because he has
29 is
obtained
not
the
applicable
MSME.
in this. Acha, it's an MSMA. Because in
Cleverly, he has got the MSME certificate.
uh,
I won't go into that. Actually, the FCs are also his people. These are not the banks or the NBFCs.
okay. No, because there is judgment of Supreme Court which said there cannot be Hydra head popping out all the time. So once the resolution process has achieved finality, all the claims as on that day are over.
Or is it suggested that since now no resolution plan has been placed, should we initiate civil suit? But the moratorium is there.
You can't, since till the time moratorium is there,
Okay.
you can't
Got
initiate.
it, sir. One question, I got your answer. I agree with that. One question is very related to this. Suppose if I could have initiated civil suit, then also those financial creditors have initiated NCLT proceedings. Then that would
See,
have affected civil suit.
if you would have initiated a civil suit, while it may have been stayed, but it does not die down. Tomorrow, if you go, they will have to consider it, of course, as part of their process. And tomorrow, if you have a decree of a court or if you decree of a court, you can enforce it as
Got
a
it.
claim. As a claim.
Okay.
There are
Got it.
judgments, 7 Cs and all are there, where they have discussed. In fact, I was doing a matter which came before Justice Nariman. It was part of broader ILFS matter where some parties got a order of a civil order of a court from Madras High Court somewhere, a decree, and the court said that you will have to consider it as a part of your resolution process before you go further, because therein your claim has
But no
been
decree is passed. Suppose no decree is passed and the process NCLT is started,
then you are stuck. Then you're stuck.
Got it, sir. Got it.
But the CD will have to tell the RP that there is a suit, so there is a claim which is pending adjudication, right? And
Yes,
therefore,
sir.
therefore the RP, therefore the IRP or RP, whoever the case is, they will have to sort of take it into consideration in their plan, which is if and when submitted and if and when approved by the NCLT or the COC
Okay,
as the case may be. So if there are no other questions, then I think we can end it here.
Is there any other questions from your end?
No, nothing, ma'am.
Okay. Yeah, sure. Thank you, Vikash. I think we had a wonderful and interactive session.
I hope so.
No, we really enjoyed it. And thank you so much. Yeah.
Thank you, everyone.
Thank you, sir.
Thank you. Have a nice day.
Yeah.